All right. Well, welcome to AI Companion App Civil Discovery and the Family Law Client. I am Ryan Wedeking, co-chair of Beverly Hills Bar Association's Family Law section. The Family Law section is sponsored by White Zuckerman, Lawyers Mutual, SoberLink, and Our Family Wizard. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn more as to how they may be of service to you at wzwlh.com. SoberLink provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted legal monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced recording, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. For 5 decades, Lawyers Mutual has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of areas of practice, including family law. Learn more at lawyersmutual.com. Our Family Wizard is a co-parenting platform designed to help families communicate more effectively, reduce conflict, and create reliable court admissible records. Features like tone meter, shared calendars, expense tracking, and in-app audio and video calling help support compliance. Help support compliance and better outcomes for families navigating custody matters. I will also be remiss if I didn't mention our family law section meetings, which happen on the third Wednesday of each month. Our next meeting will be this coming July 22nd at 4:30 p.m. And just a plug for the family law section meetings. It's a great way to stay plugged into kind of the state of Department 2. Judge Kaufman appears at all of our meetings and kind of gives everybody the lowdown on what's happening in Department 2. It's a great opportunity for networking, and it's also a great opportunity to get a little CLE in too. We don't give credit for the little CLE features that we do, but we do 5 to 15-minute little modular CLEs on a different family law topic each month that will keep you all sharper. So I am delighted to introduce our speaker today, Hossein Berenji. He has a very fascinating topic on AI companion apps and civil discovery, very thorny issues that I think we are all working through and trying to navigate. So I think we've got a great program for you ahead. Mr. Berenji is the founder and managing director of Berenji Divorce and Family Law Group, bringing over 2 decades of focused experience representing executives, business owners, and high asset individuals in complex, high net worth divorce and family law matters throughout Los Angeles County. Known for his strategic precision and meticulous preparation, he has consistently secured multi-million-dollar property settlements, favorable support orders, and strong custody outcomes while advising clients through every stage of litigation, negotiation, and alternative dispute resolution. A UCLA woohoo and Loyola Law School graduate, admitted to the California bar since 2001. Hossein is recognized for his professional excellence, serves as a member of the LA County Bar's Family Law section, and is committed to community service through pro bono work for domestic violence survivors and a family law scholarship he established at Loyola Law School. Now, Hossein, please take it away.
Thank you, Ryan. Thank you. Hi, everybody. And I'm going to start sharing my screen for the PowerPoint. And I think that a lot of us have been Sorry, let me make sure I got the right second. Go. All right. Yeah, a lot of us think about AI and the use of AI in either our practice, thinking about what's ethical, what's not ethical. And we know that a lot of our clients are using AI. I mean, personally, I have clients who call me and tell me, well, AI told me this, should we do this? So AI is being used for strategy. AI is being used for people to find information out and get a better sense. And while it might make our job easier sometimes because our clients maybe have some of the information, it does create a level of liability for them as they move through their divorce case. And the focus today is to concentrate on what these clients are using these AI apps for a multitude of things. Sometimes it's law related, sometimes it's about their case, sometimes it's general knowledge. And sometimes with the companion apps, they form some sort of a bond with these AI apps. They use it for therapy sessions and whatnot. So the idea of this program that I came up with is to really look at how they're using these AI platforms. What are the concerns that we as litigators have with our clients using these platforms and whether they're discoverable or not? So we're going to go through a few concepts. The main one is first the AI. What's the difference between the regular AI chat and the AI companion, and how does Senate Bill 243 affect the obligations of these AI platforms into safeguarding the consumer? But more importantly, we want to get into how does it really affect our practice of law? How does the disclosures, that discovery, can you subpoena these AI platforms for information? What's protected, what's not protected, and what type of information do we need to inform our clients about? I mean, we got to let them know that if they're on a chat, it's not private and it could be discoverable. Now, why is this important, right? You have situations where clients are constantly using AI. They are, like I said, they do searches on how to do things, but more importantly, what if they're using things and they're sharing things that we as litigants we don't want our clients' private thoughts coming out if it's not communicated with our firm protected under the attorney-client privilege. A lot of people think that this is private, but it's not. And one hypothetical I have is if you have a new client who comes in and says, I know my husband is using AI and he's trying to either, do something nefarious, hide assets. Maybe somebody has some emotional issues and they're talking about AI about suicide. Some of them, maybe they're planning on hiding assets. And your client comes up with this hypothetical. I know my husband, he spends hours on his computer every night. He uses ChatGPT for his work, and I suspect he's been using ChatGPT or another AI platform to help him plan this divorce. Can we find out what he has shared with AI that might help our case? Well, I think as litigators, we know that that could be a ton of evidence, okay, there. You have somebody who is sharing their deepest thoughts. Now, the question is there a therapist-patient relationship? Is there an attorney-client relationship? Is this as if they're talking to somebody that there is no privilege? And these are very interesting topics, and it's very important for us to be able to go through these and discuss what the ramifications of these discussions are. Now, let me see here. There we go. All right. Now, what are these people talking about? Divorce strategy, custody concerns, parenting frustrations, financial planning, support obligations, hidden assets, mental health, I think you guys get it. And this is really information that would potentially be very damaging for somebody if it comes out, and if it's not kept private. Now, what the idea of this presentation is to discuss how AI is used, the application of SB 243, and go through the steps and the law, current law, that establishes how discovery, how we can apply discovery and what we can do to get this information. And by knowing how this information can be exposed, we can advise our clients to protect, not only litigate and get this information for the benefit of our client against the other person, but also advise our clients to protect themselves as they're going through the litigation process. Now, AI companion apps are very different than ChatGPT or another Claude. AI apps, companion apps are really designed to develop a relationship between the user and AI. And the fundamental platform is there to engage with the user, to have an emotional connection, and discuss their interpersonal problems with these platforms. I mean, it's built for that. And the legislature found it within its vast knowledge that it needs to protect people. Now, you have regular AI platforms like ChatGPT, Claude, Gemini, Grok, and Microsoft um, Copilot. Some of the companion platforms are Replica, Character.ai, Nomi, and Kindroid. They're very different. Their targets are very different. The way the platform is set up is very different. So, what does the legislature do in order to protect individuals? Well, SB 243 was implemented precisely to make sure that there are safeguards in place where users of the companion platform understand that this is an AI agent you're talking to. It's not a real human being. To ensure that there are safeguards protecting the user, they recognize that whatever emotional ties they might have with this platform, it's artificial intelligence. It's not a real human being. It will identify suicide and health and self-harm chats, and there are protocols to protect the user. There are other protections related to minors and vulnerable users. And there's transparency because these AI apps have to provide to the government, to the state, the safeguards that they have implemented. So there is accountability. And why is it necessary? Well, it's necessary because patients, I'm going to say patients, well, they're not patients. They develop this connection, and there's no attorney-client privilege. There's no therapist-patient relationship there, and people need to be well informed that this is an AI platform. Now, the use of these platforms are different. The way the information is saved, though, is the same. Okay. So even though these platforms are set up in a way to attract different conversations, the way the information is set up is the same. So the question is, how can you access this information? Okay. When people are using this for personal, and this is a little redundant, so I think I can skip this particular slide, but the idea is that they're sharing their most intimate thoughts, and it could be discoverable. And how could it be discoverable? Well, once you get this information, um, the platform will have not only your chats, there's a discussion, and people will have multiple conversations and they'll get deeper and deeper in their particular issue. Um, and then the unlike the diary where you would, jot down your thoughts, there's a dialogue and you're sharing more and more. And these apps are made for you to share more and more. And they offer recommendations. People have refined their thoughts. So a simple statement could turn into a long chat where either their most intimate concerns or issues come out, or their plan of how to hide assets come out. And this will affect, the information that will be disclosed. Now, sorry, let me this out here way. Now, again, why does all this matter? Well, because we are using all the evidence in our disposal to be able to help our clients. When we are subpoenaing a bank, or we are asking for journal entries, or we are asking for particular emails where people are communicating and it might be not protected. It's important because it deals with their credibility, their intent, their parenting judgment, financial disclosures, their mental health. And I think all of these topics will have an impact on their case. Sorry, give me 1 second here. Now, the key takeaway from this section is that artificial intelligence represents a new category of electronically stored information. Anything family lawyers have previously incurred. It's nothing like we've encountered before. These conversations are real. People are sharing their thoughts, and we need to be able to protect our client or get the information. Now, are these conversations confidential? The first case that has come out is United States versus Heppner. In this case, you have a criminal defendant whose electronic equipment was seized by the government. And as a result, they were able to get into his chat information. And he tried to prevent the government from using his chat information. And his argument was that this is similar to an attorney-client communication that should be private. And the question was, is this a attorney-client privilege or a work product? And is there any protection? Now, the court answer was clearly no. Okay. There for several reasons. One, that this chat or any other AI platform is not a lawyer. There's no fiduciary. There's no agent assisting counsel. And there's no part of a protected attorney-client relationship. Our users are also told on these platforms that their chats are going to be used by the AI for training purposes. But what the holding kind of left open with some ideas, okay? And it is that the attorney-client privilege depends upon a trusting human relationship involving legal and ethical duties. But it did also distinguish general free, let's say like free platforms or the enterprise platform. Or it also discussed whether if something is done at the advice and request of an attorney. So the court did limit its ruling to the facts of this particular case. But in its holding, it did open up the idea that maybe if a person is using an enterprise version where it's not public and there is a expectation of privacy, that maybe their privacy rights would overcome the ability to discover those communications. It also left open that if there's communications that are at the request of an attorney, it might fall under the work product doctrine. Now, what Heppner did not decide is whether AI providers may be subpoenaed, whether the Stored Communication Act applies to all AI conversations. We'll talk about that in a few minutes. Whether the enterprise AI system used under the direction of counsel should be analyzed differently, whether AI companion apps present a different privilege issue, and whether every AI conversation is discoverable. These questions do remain open. There are there is a case of Cobble. Sorry, I skipped one slide. This is a seminal case that discusses that there is an attorney-client communication that may extend to communications involving when the third party is participating in a reasonable, necessary, sorry, I'm having some technical difficulties here. Okay. Reasonable, necessary to assist the attorney in providing legal advice. We're talking about interpreters, we're talking about accountants, and under the Covell case, a third party who functions as an extension of the attorney in facilitating the attorney's ability to render legal service is protected under the attorney-client privilege. So this notion could potentially be an argument that could be used if the attorney is advising the client to use some sort of an enterprise AI system or a closed circuit system to give it legal advice. Okay. And this, I'm sure, will be coming up for analysis by the courts in the near future. But it has not been decided whether the Covell would be applicable to AI and how it would be applied, because there's no cases yet, published cases that deal with this. I've created a little chart so that you can kind of see different scenarios in which potentially the courts might rule given this current state of law. A client independently asks ChatGPT or Claude for legal advice. Under Heppner, likely no attorney-client privilege or work product protection. Client independently asks AI to draft legal arguments or litigation strategy. Again, Heppner analysis likely applies, no attorney-client privilege. An attorney directs a client to use the firm's secure AI platform to assist counsel. That's an open question. Under Covell, this principle may be argued and guarded, and maybe that communication becomes protected. Attorney uses an internal enterprise AI to organize discovery or analyze evidence in anticipation of litigation. This is what we typically think about AI use in our practice. Us attorneys kind of using AI to assist us. That is a possible work product analysis, and it is unresolved. Attorney uses confidential enterprise AI integrated into the firm's legal workflow. Again, this is a possible work product analysis, and I believe it could be protected. So the key takeaway is that the Heppner court applied traditional privilege principles to a litigant's independent use of a public AI platform. Whether those same principles apply when AI is used under a direction of counsel or as part of attorney litigation workforce remains open, and it's an important unresolved question. So don't just assume that all the work that is being done on our own private platforms is protected. Obviously, logic dictates that it will be, and I think a court's going to come down for protection, but there is no public decisions at this point on that topic. Now, can we get how did this Discovery Act work with respect to civil discovery, with respect to these AI conversations? So you are going back to our hypothetical. You have a client who says, my husband is using AI and he's planning. Can we get that information? And how do we get it? Okay. Now, first and foremost, this issuing a subpoena is going to be a challenging process, and I'll get into the subpoena in a few slides. I think the most important is you should begin by sending requests for productions, special interrogatories to the opposing party so that you can get the information from them. Just like we would use that to seek emails and text messages, financial records, or social media content directly from the litigants, AI conversations should be requested as well from them directly. Now we get an objection. We get an objection to the request. We get information that says, "Oh, no, they don't exist." Just like how do we trust that answer? Do we just take it and say, "Okay, it doesn't exist"? What can we do? So the objective is not to discover every AI conversation. The objective is to discover AI conversation concerning issues that are real to the case. So when it comes to objections such as overbroad, invasion of privacy, we're going to have to build questions that are very, very specific, okay? And so that there is no objection about the overbreadth of the request, okay? My apologies. Okay. So in terms of how, I'm sorry, let me just put this. Um, so the most important is to understand the different categories of AI data that is critical for drafting your discovery requests. Okay. And when you are preparing your request for discovery, it should be focused on specific conversations that might have been discussed with AI, not whether the opposing party used AI. For example, requests may seek AI conversation concerning child custody, child support, financial disclosures, domestic violence allegations. Their relevance comes from the subject matter, not the platform. Depending upon the circumstances, counsel should consider requests for production, special interrogatories, requests for admissions or depositions. Artificial intelligence has created a new source of electronic stored information. It has not created an entirely new system of discovery. So we still have the same tools. We just got to fashion our requests to fit the new technology. Now, I have a sample request for production here. So you define artificial intelligence. And obviously, just like we have definitions in our request for productions, this is a good definition, I believe, that could capture a lot of the communications in these platforms. And then your requests need to be specific to non-privileged artificial intelligence conversations, prompts, responses, uploaded documents, exported chat histories, saved conversations, project files, and other AI-generated communications in your possession, custody, control. Now, then you could put the topics, the specific topics. So we need to define the artificial intelligence platform. We need to define what we want from the platform, what files we want, and then we can discuss specifically the topics that the responding party has used, what topics they've used ChatGPT for. You can also create special interrogatories, okay? And that's a little bit, you obviously have the same definition, but you can create special interrogatory that identifies for them to identify each artificial intelligent platform, chatbot, or large language model. Large language model was, when I was doing this research, was something new to me. I didn't know about that phrase. That you have used from the date of separation to the present, for example, or even before, relating to this dissolution proceeding or any issues arising from it. So the purpose of these two slides is to show that we're gonna use the same tools, but we just have to be aware of what we're asking for, have it be specific, related to the topics, and cover not only the definition of AI platforms, but the files within each platform that we're asking for. And you can always anticipate objections. And I don't think I need to go through the objections, but the privacy is a huge one. The overbreadth of the request is another one. Attorney-client privilege, work product doctrine, patient privilege. And I think obviously getting the Heppner finding, I think the attorney-client privilege would not really apply unless, again, it is at the discretion of an attorney under Covell. But again, no published decision has been rendered yet. Again, as with all discovery disputes, ultimately, it would go in front of a judge, and the court's going to have to do the balancing test between privacy and the right to get the information. Now, some key takeaways: artificial intelligence should not be approached like every other source of electronic stored information. The same principles of relevance, proportionality, privacy, and privilege continue to apply. The difference is simply that AI has created a new repository of potentially. I'm sorry, I'm just going to turn off my phone. Somebody's really trying to get hold of me. All right. It does create another repository of potential relevant evidence. Okay. Now, what happens if you get somebody that says, "Hey, I never used AI, and I don't have any of this information"? Can we go directly to the AI companies and subpoena them? Well, subpoenas, if you have ever tried to subpoena any phone records, you're going to get some sort of denial by the phone companies. And they're going to say, "Hey, I want you to get the permission, a written permission of the account holder to be able to get this information." That's because of the Stored Communication Act. And that is an act that was passed in 1986, and it prohibits providers of an electronic communication service or remote computing service from knowingly divulging the contents of stored communications except as authorized by statute. And there are some exceptions. The civil, for purposes of the civil case, such as a family law case, there is no exception. And these are the exceptions that are part of that case, but it doesn't apply to our case. That's why I've experienced this. I'm sure you guys have experienced this. You send a subpoena, it comes back, you need permission from the account holder, and that's very difficult to get. Now, there are no general exceptions permitting disclosures. Okay. So the issue is, does the AI platform fall within the protection of the Stored Communication Act? That is a fundamental question that has not been answered by the courts. Now, my own experience, I'm involved in a case where I suspect that the other party has used an AI platform, and particularly Anthropic. I have reached out to Anthropic, and I've asked about subpoena, about serving the subpoena on them. And I got the response that Anthropic maintains the position that the issue may ultimately have to be resolved through a motion. They take the same position that it's protected, and it falls within the protections provided under the under the Stored Communication Act, and therefore we're going to have to involve the court or get permission from the user. Now, the legal basis of Anthropic is based on the Stored Communication Act. However, okay, those cases that involve the Stored Communication Act are typically involve emails, social media communications, not artificial intelligence. They currently provide the legal framework provided that is they will object to the request because historically the act was there to protect emails and social media communications and phone communications, phone records. Now, I want to talk about some of the principles that the Stored Communication Act is based upon, and some of the cases that have analyzed the Stored Communication Act, so that we can distinguish the AI platforms and artificial intelligence in making this argument for the court if you happen to file a motion to compel. Now, under in re subpoena ducitucum to AOL LLC, This is a 2008 case. A civil litigant served a subpoena on AOL seeking the contents of a subscriber's email communication. The holding in that case was that the 18 USC 2702 prohibited AOL from disclosing the contents of the subscriber's communication because the SCA contains no exceptions permitting compliance with the civil code. Well, this is very clearly supports what the legislature intended at that time because they didn't produce the records. Now, under another case that supports non-disclosure is the holding on Crispin versus Christian Adiger. In this case, the plaintiff sought private Facebook and MySpace messages directly from the provider. Again, the holding held that the private social media messages may be protected by the Stores Communication Act and emphasized that the statute broadly prohibits disclosures except where Congress expressly created an exception. And again, civil subpoenas in a family law case do not fall within that exception. Now, the Crispin extends the SCA protection beyond emails and private social media messaging, and it reinforces that the courts will not honor a subpoena and they will not give you a motion to they won't grant your motion to compel if it doesn't fall under those exceptions. There's another case of Cheston versus Franklin. That's a 2010 case. A civil litigant sought electronic store communication mainly by a third-party provider. The holding in there was that in that case, the court recognized the Store Communication Act generally bars providers from producing protected communication in response to a civil discovery. Now, this decision reinforces the litigant's ordinary that the litigant ordinarily must seek electronic store communication from the account holder, not the provider. Now, so we understand that this is pretty much settled law at this point when it comes to emails, social media posts, phone records, but how does it apply to the AI platforms? Now, the act was enacted, and looking at the legislative history would give us an idea of what the purpose was. Okay. The purpose was to protect the privacy of electronic communications stored by third-party service providers. Okay. And it started when people were starting to using the internet for communications. Congress was protecting private electronic communications between people. And this is a fundamental difference. Prior to AI communications, all the communications that the Electronic Communication Privacy Act was protecting was communication between people. But this is where, AI intelligence is not a person. And that's a huge distinction. Now, the open question is, did Congress intend that the Stored Communication Act also apply to conversations between a human being and an artificial intelligence? At present, no reportable appellate courts have squarely answered the question. But emails and text messages involve communications between human beings. AI conversations involve a human communicating with software that generate the response. And the United States versus Heppner comes back into play because that tells us in that decision that AI is not a lawyer, there's no fiduciary, it's not a human, and there is no confidentiality between this electronic platform and the user. Now, the question is, Congress never considered AI in 1986. So this is new charter territory. So I think there's a lot of arguments to be made that the SCA doesn't apply to the communications with AI platforms. Now, I want you to assume the following. The court orders production of responsive AI conversations. The opposing party responds, there's no responsive AI conversations exist. The AI provider refuses. I'm sorry, I think there's a typo in here. I think the issue is we do an RFP for AI. The responses, they don't exist, and the platform refuses to produce the documents. Now, how do we verify this? This is the gap, right? Is the responding party being truthful or are they not? Can we just take them for their word, or do we need to take this extra step and subpoena the platform to make sure they're telling the truth? Now, because this is uncharted territory and we don't have a case law on it, there's some things you can do to help yourself try to get the information. You can serve targeted discovery directly upon the party. You can send a preservation letter to the individual, to the responding party, for the AI communication. You could request that the court order the opposing party to export and produce responsive AI data. And you can also ask corroborating evidence from browsing history, billing records to see if let's say if they have a subscription and they're paying it with their credit card, screenshots, downloaded experts, uploaded documents, or other electronic stored information. There's also some now ways to figure out if communications are AI generated. There are platforms where you could upload information and it can tell you whether it's AI generated or not. So those are some tools that people can use to just figure out if this person is lying or not, and ultimately issue a subpoena and go through the arguments that we discussed in a motion to compel. Key takeaways: the Stored Communication Act currently presents the greatest obstacle to subpoenaing AI providers. Until courts provide additional guidance, practitioners should seek AI conversations directly from the opposing party and preserve them early in the litigation. The verification gap may become one of the defining discovery challenges in AI litigation. If providers' subpoenas are limited and the verification gap remains unsolved, the final question becomes, how should family lawyer counsel their own clients regarding the use of artificial intelligence during litigation? Now, my personal belief is that given the Heppner decision, I think that we can definitely pursue a subpoena. I think we could definitely distinguish AI communications from the traditional communications provided by the SCA. And I think that is the strongest approach if you can't rely on the responses from the responding party. I personally, when we get responses and I can go to the source, a bank, and subpoena credit cards and bank accounts, if I'm not getting the truth, that's my go-to process in discovery. And I think good litigators do that. They just don't rely on some response from opposing party. They do their own due diligence. And this is the verification gap that we all will inevitably deal with in our cases. And I do think that this is a very fascinating topic. There's a lot of argument that could be made that AI intelligence is not a human being, and therefore it should not have the same protection as such other communications, signals, and social media communication. That's the end of my presentation, and I will open I guess we can have, let me end. All right.
All right. While we wait for questions, do you, Hossein, have any additional points or anecdotes that you'd like to discuss?
Well, I mean, I think if I come back in a couple of months, I'll have a little bit of I might have some personal experience in this in the case I'm working on. Other than that, I think one of the things that I didn't touch upon because I really thought I was going to run out of time, and I have a little more time, is what do we do with our own clients? And I think that is very important. Do we advise them that their chats could do we warn them about not using just like any I tell my clients early on what to do and what not to do. I have a list of do's and don'ts, right? Don't talk about your case with third parties. There's no confidentiality. Be careful what you share. Things of that nature, right? So I think that we've incorporated in our do's and don'ts, don't use AI, a platform, or if you're going to use it, just be cognizant that you are not talking to a human, that there might not be a privilege, you might not have the expectation of privacy, and you might have to disclose the information, or it might be subpoenaed at a later time. So I think that all of us do have a duty to our clients to inform them about the possibility of their AI chats being disclosed, discovered, and to make sure that they are cognizant of that.
All right, looks like we have one question so far. Cedar asking, what records should experts retain?
What records should experts retain with respect to? I'm not understanding the question. Sorry.
All righty, we can try to get back to that one. I do see some within our help desk. Do you think Heppner will ultimately be limited to public AI platforms, or do you expect courts to extend its reasoning to enterprise AI used within law firms?
Well, the Heppner decision did open that idea up. The judge did say and distinguish kind of a public platform or a free platform from enterprise or the communications with kind of at the discretion or advice of an attorney. Uh, I, I think there is a distinguishing factor between Covell, where the communication is at the advice and request of an attorney to assist in the litigation. I think that is different than using an enterprise. The only thing about the enterprise, the difference between enterprise and the free version is that your communications are not being used for training. But the rest of the points that the judge raised, it is not a human, so that's the biggest thing. It is not. There is no confidentiality relationship. There is no fiduciary relationship. There is not an attorney. So if we analyze this in kind of a practical sense, it's kind of like you walking in the hallway and speaking out loud about your case. Anybody who's walking by can hear it. Or the standard, you're in the law office and you're either talking loudly and yelling the doors open. Anybody who walks by can hear it. Is there privacy? Or if you're closing the door. So the question is, will the courts consider your communications with an AI agent, whether that's like you are in a room, closed room, and having a private conversation, there's an expectation of privacy. If you take that analogy, then yes, the enterprise model could potentially provide protection. But again, the court really emphasized the human to human communication. And if courts go down that set of facts, it's not a human, and so therefore you're not having a communication with it. There's no privacy, or goes down to the example of having a communication in a closed space without people hearing it. If you go down that type of analysis, then there would be protection. I could see both. I really do. The question is your expectation of privacy, just like any other communication. Is there a reasonable expectation of privacy? And maybe there is expectation of privacy with the enterprise platform. So, I mean, if I was a judge and it was an enterprise platform, I would probably say there might have been a reasonable expectation of privacy if those safeguards are in place where the information or the chats are not shared with the AI to learn.
All right, looks like we have a comment regarding the previous question. What records should experts retain? And then the follow-up, the documents listed in your slides of queries, etc. Should I produce my searches /chats. How is this different from regular web research?
Well, I mean, I think that the the regular web research, I mean, that's a great question. The Heppner decision, this was discussing the communications with an individual versus an electronic platform. And if you are doing your searches, let's say you're doing searches online, um, how is that different from, texting a friend about something very intimate or something that is related to something that occurs? Are those text communications private? In terms of whether it's the same as a search, a Google search, what have you, is it the same? Is that discoverable? I think the analysis is very similar. Typically, when you do a search on Google, your search history does not save you do search, you're not interacting with it. You might search, how do I not report my income? And you get a bunch of searches. I think it's a far stretch for us litigants to use that search and claim, look, he searched, how do I hide income? Therefore, he's hiding income. And I think that the level of communication is the difference between an AI search and a regular internet search, where you are just pulling up articles, reading, procedures. You're really interacting, and you are prone to start discussing how to do it. I have this business. I have this business overseas. I don't want to report the income. I have, my wife found a suicide note, but how do I deal with that? Or, things of that nature. So you start interacting, and I think it's very different than doing a search. And I think that's where the trap is. The trap is that you can get a lot more information from the AI platforms than you can from a search. And if you do a search, how is that going to provide any information that you're really attempting to hide assets? But an AI platform, you're engaging, you're asking questions, you're asking, how can I do this? How can I? So I think just the level of communication is probably different. But in terms of the concept, is probably the same. I think the searches have not hit the courts yet, but I think the AI, you searching AI platforms, I think they will. Those issues will come up.
Great, thank you. And let's see, it looks like we have another question here. Just one moment as I apologies. There we go. All right. If an AI provider refuses to comply with a subpoena under the Stored Communications Act, do you envision challenging whether an AI conversation is even a communication protected by the Act?
Absolutely. I think that was a fundamental difference and you would use the Heppner decision at this junction to extract certain findings that the court made, certain dicta that shows that while the Heppner decision was focused on the attorney-client privilege in its finding and the question, the opinion, if you read the opinion, does discuss some of the fundamental reasoning behind it and the fact that it's not a human. So I think if you do subpoena an AI platform, I think you can distinguish it between looking at the legislative intent behind the protection. It was supposed to be between human communication, and all the cases that have come up, and we cited several cases, those all dealt with communications between humans. And therefore, the question is, does this fall within the same type of protection that Congress attempted to protect? And I would argue that the Heppner decision does distinguish AI communication between AI communication with communication between humans. And I think that might be the strongest argument at this junction until we have better legislative rulings on this issue, direct issue.
Alrighty, and let's see, it looks like we have one more. Have you seen AI conversations become significant evidence in actual family law cases yet, or is this still largely anticipatory?
It's anticipatory. Again, we are attempting to, on one of our cases, obtain those type of communications. I'm anticipating that it will, just because of what I know about my own usage of AI. If you are using AI, you are communicating with AI, you are asking questions of AI. If somebody's going through a divorce process, I have clients. I have clients who come to me and we're talking about, let's say, support. We're talking about division of assets, custody, and they come back to me and they say, "Hey, I've done my research, or this is what AI tells me." And I've had many clients do that. I honestly, I would say about 20%, 25% of my clients are coming to me about their AI search, and they're trying to tell me about what they think should happen or not happen. And I think if they're using these platforms, I think there's a ton of information. If my clients get subpoenaed, there might be communications that they're using that is discoverable and can affect their case. So I would assume that there is, although my perspective is it's usable just from what I know. That information is important, and I think it will affect the cases.
Alrighty, it looks like that we are just about at time. Do you have any other concluding remarks that you'd like to make, Hossein?
No, I'd like to thank the Berenji Bar Associates for having me on. This is a very fascinating topic. I started this with writing an article in a daily journal, and I think it was picked up. And I think that there's a lot more in this arena that needs to be explored. And I'm embarking in this challenge myself with Anthropic, and I'm really excited to see where it goes and how far it goes, because I do think that the information, especially on the public AI platforms, maybe not enterprise, there's a lot of exposure there, and they yield a ton of information that could be useful in cases. But again, I thank you for everybody for participating, and I hope it was informative.
Great. This concludes today's presentation. Thank you so much, Hossein, for an excellent presentation today, and thank you so much to our audience for joining us. Have a great day, everyone.